163, Killon versus Parrotta. Thank you. Counsel?
Thank you. If it pleases the court, my name is Greg Canale, and I represent the appellant, Mr. Robert Parrotta. I would respectfully request 2 minutes for rebuttal.
You may have 2 minutes, sir.
Thank you.
Welcome.
When the appellate division in this case vacated a unanimous jury verdict and resolved a factual issue that the appellant was the initial aggressor, despite the fact that a jury was specifically charged on this issue and specifically instructed on the law concerning initial aggressor, and when the lower court found as a matter of law that the appellant was not entitled to justification because they found that he was in fact the initial aggressor.
Counsel, is the thrust of your argument that the appellate division used the wrong standard when they initially reviewed this case?
Yes, I think
And so what standard should they have used?
it is quite clear in Hallmark and in Campbell versus Elmira that any time a factual determination is being set aside as a matter of law, the standard to be applied is the utterly irrational test. This jury verdict should not have been set aside unless the majority below determined that the verdict was utterly irrational. Now, I understand that the majority of the lower court made reference to the weight of credible evidence standard. But as soon as they set that standard out, they then immediately engaged in a sufficiency of evidence analysis.
So is the remedy that we send it, if we agree with you that they used the wrong standard, is the remedy that we send it back to the appellate division, or what would you suggest is the remedy?
The remedy I would suggest is the one alluded to in Martin v. City of Albany, whereby the court concluded that had the appellate division in that case vacated the jury verdict based solely on a matter of law issue, they would then be entitled to reinstate the jury verdict. That is exactly what happened here. The verdict was set aside as a matter of law issue, which was an incorrect determination. I submit to you that unless this court finds that that verdict was utterly irrational, the verdict should be reinstated and the appellant should be entitled to the benefit of the jury verdict. I'll move on to my second point, and that is the majority, not only did they find as a matter of law that the appellant was the initial aggressor, thereby prohibiting my client from asserting justification in the second trial, but they also applied what I believe to be the wrong standard in determining what constitutes an initial aggressor in this particular circumstance.
What did you disagree with the charge that was given to the jury in the original case, the original trial?
No, I did not, and I believe that that charge was a valid charge, aside from the point that was made by the both majority and minority of the lower court, and that was that verbal threats should not be considered in determining who the initial aggressor was, contrary to this court's holding in People
Well,
versus.
let's talk about that for 1 second. The defensive justification in the statute requires deadly physical force, but the charge that was given, and you both probably know better than I do, but I think the charge that was given, the trial court said uses or threatens the immediate use of physical force, not deadly physical force, and there was no objection to the charge, was there?
No, there was no objection to the charge.
So my point there is if there was no objection to the charge, then that charge then becomes the law of the case, since no one objected to it at that time.
I totally agree with that. However, you can use justification regardless of whether the force used was deadly or not. It's the person who first resorts to the use of physical force. My position was, and my second point on appeal was, that when two people are engaged in an encounter, an argument, and it could be reasonably said that the appellant was the one who initiated the confrontation, it would then be, the definition of initial aggressor would then be the one who first resorted to deadly physical force, which is exactly what happened here. You had two people arguing, both possessing weapons, both hurling verbal insults at each other, and the first person to resort to deadly physical force was the respondent, which difficult for me to understand how the majority below said, despite that fact, that was a very crucial fact, and in arriving at their decision that it was the appellant who was the initial aggressor, they seemed to treat that fact
Well,
as...
there were some...
Did your client have the duty to retreat?
No,
Why is that?
he did not have the duty to, well, he had a duty to retreat, excuse me. However, the jury determined that he was not capable of retreating. Leads me to an interesting point as well, Your Honor, and that is,
Can I just stop for a second? Aren't we leaving out a lot of facts here, like he drove for 20 miles, he had been drinking, they'd been engaging in arguments before, they both had, one had a maul, I guess, which is an axe handle, and the other one had a baseball bat. There seems to be a lot of circumstances here that make this a uniquely factual determination.
well, that is true. And that's the point of having a jury trial decide the case based on the facts. It's always been my position that he should have never driven there. He should have never been on his property. And at the time he was on that property, he was a trespasser and should have left. He should have done 1,000 things. But that did not give the respondent the right to immediately resort to deadly physical force. And as soon as he did, he was the initial aggressor. And incidentally, as to your retreat issue, if the appellant was the initial aggressor, shouldn't the respondent have retreated back into his house? He certainly was on an open porch, not in his
The
home.
respondent has a duty to retreat on his own property?
Yes. If his duty to retreat is eliminated if he's inside his house or on a porch that's enclosed. This was a porch open and accessible to the outside. So yes, he did legally have a duty to turn around and go back inside and call the police. Hey, there's someone on my property, he's trespassing. He did not have the right to immediately resort to deadly physical force. In closing, I would just like to state that as a bedrock principle of our judicial system, that any factual issues, and there are a lot of them, but these factual issues should be left to the determination of a jury. Thank you.
Thank you, sir. Counsel?
May it please the court, my name is Joe Brennan, and I represent the respondent in this case, Stacy Killon. In this case, the appellate division majority made a determination that in fact that the evidence presented at the trial was contrary to the weight of the evidence in this case. And I think that's amply supported by
Counsel,
the record.
If they did that and they remitted the case to, or remanded the case to the Supreme Court for a new trial,
That's correct.
was the trial judge wrong in interpreting the appellate division's original decision that the defendant here, Mr. Parrotta, the appellant, was the initial aggressor?
No, I don't believe that he was wrong in that regard. I think in this case, and I agree with Judge Fahey, I think this is a really factually extremely significant case.
So
There's no
you're
question-
saying, as a matter of fact, the appellate division determined that Mr. Parrotta was the initial aggressor? And
Yes.
so it's not a matter of law, it's just a matter of fact?
Yes. I think that is a matter of fact, or certainly a mixed question of fact and law as to whether or not he was the initial
Why wouldn't the second jury have the opportunity to review that fact?
I think
He
I
was
think
the
the
initial
second
aggressor.
jury did it. The defendant in this case was not precluded in any fashion from offering whatever factual evidence he wanted to present it at the second trial. And in fact, the trial court charged the jury that they could consider who the provocateur was here in assessing whether or not what
Is
the
that the same
damages should be.
as having a second jury have the charge of justification given to it?
No, what happened with regard to the second trial is in view of the appellate division decision on the appeal, the decision of the majority. At the second trial, counsel for the defendant was requested as to whether or not the evidence would be presented on the issue would be identical to what was presented at the first trial. And the response was it would be. And on that basis, the trial judge said, therefore, based on the appellate division determination, that in fact the justification defense would not be afforded. I submit that factually here, if we start from where this thing began, and I think, as Judge Fahey points out, that in fact the defendant in this case drove 20 to 30 miles.
Look, can I interrupt you for a minute?
Certainly.
If the appellate division said in a wholly different case, there was no proof that there was a gun involved in this altercation, and therefore, we're setting aside the verdict and setting it back for a new trial, could the person who was asserting that there was a gun then introduce the gun in the second trial?
I think in the way the determination was here, Judge, I believe that would have been permitted.
So if they made a determination that justification wasn't established in the first trial, couldn't they establish justification in the second trial?
They could, yes, I believe they could offer the evidence, but I think based on the facts, that exactly the same facts would be presented by the defendant.
So that's the key, because the judge said he would not permit any self-defense or justification charge based upon the August 2012 appellate division order. But
That's
that's not true. What he's really meant to say was, I'm not going to allow that because you folks have told me that the testimony is going to be the same.
That is correct, and I think the record substantiates that. We talk about initial aggressor. I think in the context of driving there, taking a bat, pulling into the driveway late at night, being told by the plaintiff in this case that he was not to be there. The plaintiff was intoxicated, there's no question about that. Told him to leave the property on numerous occasions. He had every opportunity in the world to leave. Instead of leaving, he decided to approach the porch. Now, with the issue here with regard to whether or not he could have retreated at any point, there isn't any question, I submit on this record, that the defendant could have retreated completely without any danger to his own personal safety. I think if you look at factually what occurred here, there's an assumption being made by the appellant that in fact that the plaintiff in this case used deadly physical force. I don't think the record in this case substantiates that at all. The defendant testified that when he approached the porch, the plaintiff is on a porch, there are 2 steps, he's approximately 2.5 to 3 feet above the defendant, who is standing on the ground on this small porch of a mobile home. The roof over this porch is only, and it's in the record, at a height of 5 feet 11 inches. The plaintiff in this case is approximately 5 feet 7. He's holding this maul handle. The defendant contended that he raised the maul handle up over his head, which was factually impossible with the roof being at 5 feet 11. At that point, there's absolutely nothing that would prevent the defendant from taking a step back, retreating to his own vehicle and driving away. Instead, and what the testimony of a non-party witness here was that there was no physical contact between the maul handle and the person of the defendant in this particular case. There was no injury whatsoever. The only testimony in this case of a claim of any physical contact was the testimony of the defendant, who claimed that when the plaintiff raised the handle up above his head, which was impossible, and swung it, that he blocked it with his left arm. There was absolutely no indication whatsoever of any injury, contusion, abrasion, anything to his left arm. Then, supposedly, the handle hit him in the back of the head. There's no medical evidence, there was no testimony, there was no laceration. The only testimony was the defendant and his daughter, who claimed that there was a bump on the back of his head. Now,
And so,
under those
counsel, your view of that is that the appellate division took that evidence and weighed it
Yes,
and decided that
yes, and I
the
think
verdict, the jury's verdict was against the
was
weight of
against
the
the
evidence.
credible evidence. Yes, Judge. Yes.
But why wouldn't a second jury, you're saying it's the, getting that evidence before a second jury without the justification charge was equivalent to what the first jury was able to do in the second trial?
I believe that's the case, Judge. I believe that's the case here.
Well, if you
I-
were representing the defendant, wouldn't you want the second jury to get that justification charge so that there could be a determination?
Well,
Whether it was the initial
when you
verdict.
concede it's the same factual thing and you have a determination from the appellate division, I do not see why the trial judge would reach any other conclusion.
Did you try this case yourself?
Yes. But in any event, here, I think this is a situation where it was the function of the appellate division to evaluate the evidence. I don't think, as the appellant claims in this case, that the proper standard is that it is utterly irrational. I think the appellate division is empowered to make a determination that, in fact, this verdict was contrary to the weight of the evidence. I think once they made that determination, the proper thing is what the majority did, was to remand the case for the second trial. So I think under these circumstances, I think that determination was correct, and I don't think there was ever any evidence here which is being glossed over by the appellant. There was absolutely no reasonable basis upon which the defendant could have believed that, in fact, that there was deadly physical force being applied here. He could have retreated with complete safety, and therefore the defense of justification was not available to him in this case. Thank you very much.
Thank you, sir. Counsel?
My adversary said that, yes, as a matter of fact, the appellate division determined that the appellant was the initial aggressor. I respectfully submit that the appellate division should not be making findings of fact in a jury trial. In fact, to do so specifically denies my client of his right to a jury
I
trial.
thought that was their job, to review findings of fact, and they can make a separate factual review if necessary.
It is their job to weigh the evidence, which they did not do. Instead, they declared as a matter of law that my client was the initial aggressor, just in
Well,
case...
They did use the phrase fair interpretation of the evidence, didn't they, in their order?
They said that it doesn't support, under a fair interpretation, doesn't support. And I
That's the
know
way
we're
I
getting
read
loose,
it.
but
The
just...
reason I ask that is because it seems one of the initial determinations we have to make, is this a weight case or is it a matter of law case? So
In making that determination, perhaps it might be useful to refer to the second opinion of the appellate division when I wanted to put justification in to have the jury consider it, and they said its application, the rule of the law case said its application is exclusively to questions of law and makes a legal determination in a given case binding upon all parties. The determination that the appellant was the initial aggressor was a legal determination.
Well,
As-
I thought the determination was whether or not you could put the justification defense in secondly. That's, I think, a legal determination but not the facts of the interchange.
What they did is said the facts don't rise to entitle the appellant to justification, and therefore they struck it from the case, which is tantamount to a directed verdict on the issue of my affirmative defense.
I see.
Well, what?
Thank you very much.
You're very welcome, counsel. Thank you.